Next up on This Week in Law, Professor Matt Sag joins us along with our old friend Marty Schwimmer and Sarah Pearson and me, of course. We're going to revisit monkey selfies because we just can't help ourselves, 3D printing the history of fair use, Nazi copyrights, mega mashups, Apple Music, and much more next on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by CacheFly at CacheFly.com.
This is TWiL, This Week in Law with Denise, Howell, and Sarah Pearson. Episode 307, recorded June 12th, 2015. Monkey see, monkey sued. This episode of This Week in Law is brought to you by FreshBooks, the super simple cloud accounting and invoicing solution that can help your law firm and any small business save time billing and get paid faster. Try it free at freshbooks.com/TWiL. And by Blue Apron. Blue Apron will send you all the ingredients to cook fresh, delicious meals with simple step-by-step instructions right to your door. See what's on the menu this week and get your first 2 meals free by going to blueapron.com/twit. That's blueapron.com/twit. Hello and welcome to This Week in Law. I'm Denise Howell, and we're thrilled that you've joined us today. We've got a great panel and some really fascinating topics. We've been having such fun discussing them before the show. We thought we'd just better start and get right into it. So welcome. Glad you're here. Glad our panel is here. Welcoming back to the show, Marty Schwimmer from Leeson Ellis in New York and the Trademark blog. Long time blogger and friend. Hello, Marty. Great to have you back.
Hi, Denise. It's great to be back.
Also joining us from the Loyola University Chicago School of Law is Matt Sag. Hi, Matt.
Hey, Denise. Thanks for having me.
Wonderful to have you. Matt teaches, you're teaching copyright and IP right now, is that right?
That's right, and IP antitrust.
Right, and Matt's research focuses on copyright, trademark, patent, and competition law. So a really good mix of expertises for our topics for today, which we're going to get into in just a second before I welcome to the show my co-host, Sarah Pearson. Hello, Sarah.
Hey, Denise. Happy to be here.
Great to see you again, Sarah. Sarah, of course, is senior counsel at Creative Commons. And if you're a regular watcher of the show, then you know her well. It's great to have you back again, Sarah.
Thanks, Denise.
All right, we're going to start out with some copyright stories. So let's get to it. So, Matt, you're quite fascinated with the fair use doctrine, aren't you?
Yeah, that would be a fair thing to say.
It's a fascinating doctrine and comes up so frequently and morphs and evolves on a day-to-day basis as courts struggle to apply the 5-factor test that determines whether something is fair use. And aside from the courts struggling with it, people struggle day by day to decide if they can lift a piece of somebody else's copyrighted work and reuse it. So we talk a lot about the fair use doctrine on the show. That doesn't mean that we can give anybody any sort of clear guidance as to, in any situation, whether it's going to apply or not. But we can help people understand that it's complicated and that it might work or it might not. And that is what makes it so fascinating. We've talked in the last couple of episodes, I think, about Richard Prince and the fact that he had a showing where he exhibited paintings that were modeled on people's Instagram photos. And those paintings were selling for in the range of $90,000. This story is still evolving because people were so, on the one hand, you get a lot of people in the modern era recognizing that fair use is a vibrant part of our legal structure, and it's so important to creativity and fostering new works being inspired by old ones. But once you lift up somebody's Instagram photo and, copy it pretty close to verbatim and sell it for $90,000, people start thinking about fair use differently. So it's led to an interesting flood of different reuses then of the works that Richard Prince sold in this gallery showing, with one artist in Brazil reusing and reselling and putting in some commentary to trigger the fair use doctrine. And also, we've mentioned before on the show, the Suicide Girls reusing the works and selling their own works and selling them themselves, and sort of attempting to take back ownership of what they feel was taken from them. So this is getting very meta. And, how many levels of remove are we going to see from the original Instagram photo of people reusing and morphing these works? And definitely part as a policy statement on, gee, is this the way the law should work? So I wanted to pick your brain about all this, Matt, and see what you thought about it.
Sure. I think that the thing to understand about the fair use doctrine is the fair use doctrine is a set of rules that we get from decided cases. And some of those cases are more rule-like than others. But it's also a system for figuring out what the result should be in certain cases. So if you take the Richard Prince case, my personal reaction to that is I actually thought it was kind of disgusting. I thought, that what he did is obviously in some loose sense is artistic, but to me, I really thought, he's adding nothing other than a little bit of hubris to other people's copyrighted and expressive photos. But, there's an argument to be made, and Richard Prince should get the chance to make it. And, the forum that he gets to make it in is court if he's sued, and the framework to analyze it is someone needs to decide whether he meets the test. If I was the fact finder, then he probably wouldn't. But, as an artistic use, he has some, he has a claim to be able to make his argument. To me, this is not a convincing argument. He had a pretty good argument for some of his photos in the recent case where he'd remixed a bunch of Rastafarian photographs. But the thing with appropriation art is, to say that something is a work of art is not to guarantee that it's not infringing copyright.
Right. So let's look at some of those instances, once removed or twice removed or three times removed from the Instagram photos at the heart of all this. If the Brazilian artist copies Richard Prince's works, does he, and adds a bit of commentary, does he have any different fair use perspective than Richard Prince does? Because part of the Brazilian artist's purpose, I think, and a court could find, is criticism of the, sort of sketchy approach to fair use that you were describing and your reaction to Richard Prince's actions here. And also probably a critique of, is this actually allowed under the law? So do you think the argument shifts as it goes further down the line or not?
The argument actually becomes better and better as it goes down the line. Richard Prince is taking someone's expressive photograph and reselling it as an expressive photograph. We could infer some very complicated statement about questioning, what is the nature of art and originality, but you need to do a lot of reading between the lines. If the Brazilian artist you describe is actually commenting directly on both Richard Prince's artwork as art and Richard Prince as an artist, and that kind of using someone else's work to comment on it and to analyze it and to critique it, that's really classic fair use. So as long as that's really what is going on, that's actually a pretty easy case under US law for fair use. Whereas I think Richard Prince's case, that's a difficult case.
Mm-hmm. Virgil in IRC is asking about a comparison between Andy Warhol and Richard Prince. Do you think there's a comparison to be drawn there?
So take the classic Andy Warhol Campbell soup can. Warhol's taking an image that sort of represents consumer culture and challenging our ideas about what is art by presenting it in a really new context. I think that the Andy Warhol case, it is all of these artistic cases. They're really a question a judge or a jury has to decide. But I think that's actually a pretty strong case because the Campbell soup can was never intended to be looked at for its aesthetic pleasure. So there really is something discernibly transformative there.
Right.
Whereas, just to take someone's cool photo and say, oh, here's a cool photo, but it's large. Or, here's a cool photo of a Rastafarian, but I added a blue guitar. If you pay me, I can make the argument. But it's not as obvious an argument.
Right. Marty, how about the trademark shades here in this discussion? If someone in one of these photographs is wearing a recognizable mark or there's one in the photo, does that change the discussion at all?
Do I have to answer the question, or can I ask Matt some follow-up questions because I'm interested in his view?
Whichever you prefer.
I'd like to ask Matt, what does he think of Jeff Koons's work about the puppies? That was a fair use case where Jeff Koons took a photo of a middle American couple and they're holding a litter of puppies, and he made a sculpture of them, and he said it's his comment on kitsch. My understanding is that his sculpture was an exact reproduction of the photo, but obviously three-dimensional. So what was his view on that?
So, again, this goes back to my point that in these kind of artistic cases, what the fair use doctrine does is it gives you a forum to make your case that what you've done should be recognized as transformative and artistic and should ultimately be allowed. My personal reaction to the Jeff Koons string of puppies sculpture is that he's taken something in 2 dimensions. He's made it 3 dimensions. And to me, I can immediately see the commentary on the sort of the kitschness of the original. So, if I was the only fact finder, then Jeff Koons would win. I wouldn't, guarantee it in a case like that. But, as an artist, or if you're, talking to artists, the thing that they need to understand is that, when they come close to the line, what the fair use doctrine gives them is a chance to make their argument. And, some arguments are just easier to get a judge or a jury to understand than others. I think Jeff Koons's argument is easier to understand, although the court in that case, didn't agree. Prince's argument, it's just a little bit harder because he hasn't really done that much. It's the same thing, just bigger.
Right. It's been, even if it's not easy to answer the fair use question in all of these examples, and it might change depending on the use. One thing that has been common in the examples we've been talking about so far is the original work was a photograph, something expressive and copyrightable, with the exception of the Warhol things. So something that's recognized under copyright law as being squarely subject of somebody's intellectual property rights. But it can get muddy when you're not dealing with photographs too. And this seems like, since we're already talking about the Jeff Koons three-dimensional sculpture, a good time to bring in other sorts of three-dimensional sculptures and the whole burgeoning world of 3D printing. Sarah, do you think that, first of all, let me get your take on whether you think, since we're talking in the context of photos, if there was I know here's a perfect example, the selfie monkey, right? That started out life as a photo and wound up as something that was available for sale as a little 3D printed model that everyone who loves copyright law wanted to have on their desk immediately. So do you think the same kind of arguments would apply, or is it different in the 3D printing context?
That's a good question. I think in some ways it's really similar to the puppies case. At least that's my initial reaction, is simply taking something that is two-dimensional and making it three-dimensional, which is what you'd be doing when you're doing 3D printing. That in itself isn't a fair use. I mean, and especially, Koons had the added element of commentary, and that argument also didn't fly. With the monkey selfie itself wasn't copyrightable, so presumably they wouldn't even have to make a fair use argument. But yeah, the question of whether or not someone who makes a 3D, printed object of something, whether that's a fair use, I think it probably does raise a lot of similar issues, and it would come down to whether or not there's an element of transformativeness or commentary or some sort of element that makes it not just a physical version of exactly what the two-dimensional thing was. But
right.
Really
so the monkey selfie turns out not to be a really great example, right? Because that's a photograph that wouldn't be protected under copyright law, at least according to the Copyright Office, and not according to the person who handed over the camera and the person that has his distribution rights. So not such a great example. But if it were a photograph of anything else, then we might, say the photograph hadn't actually been taken by the monkey. Then we'd be in a situation where there's just somebody taking a cute picture of a monkey and maybe no transformative use. If you've decided, oh, that is so cute, someone will buy it and want to put it on their desk, I'm going to print it.
Right. And I think simply taking a photo and then recreating it in 3D, I think that would not in and of itself be fair use unless there's some other element at play. Because to me, it just seems like it's a reproduction in another form. At least that's my initial thought about that. If you take a photo and then just simply, make a 3D image of it, or creation of it, I wouldn't think that would be a fair use in itself. But I'm curious, Matt, do you agree with that, or what's your take on that?
Yeah, and I think that's right. Moving from 2D to 3D, or moving from any given media to another, isn't necessarily transformative in the fair use sense. You're looking for something that kind of changes the meaning or the message. So, that's why, Jeff Koons did lose that case, but, he wouldn't necessarily lose that case every time if it was litigated today, because I think most people can see that by changing the scale and by rendering it in those vivid colors and by just doing something so unexpected, there was some commentary there. Whereas if you take a picture of a monkey and you think, well, that's cute, it would be cute as a 3D object, that by itself is not going to qualify as fair use. But of course, no one's asked the monkey's opinion here.
Good point.
Yes. So let's stay on 3D printing for a moment. Much like the YouTubes of the world, there are clearinghouses where one can go to find their CAD files to make their own 3D printed sensations on their printers at home, or if they're going to go use a third-party printer somewhere. Marty, do you think by and large the same things that protect YouTube, that the DMCA works the same for 3D printing sites as it would for a video site or other online site that's protected under the safe harbors?
Well, I should start off by disclosing that I've advised both MakerBot and Shapeways about their ability to disseminate files, and I'm currently in talks with the monkey to represent him as well. But I would say that the DMCA made life a lot easier for MakerBot to create its Thingiverse file sharing website, and for Shapeways to have its model, in that if there's problematic files out there, then the website operator can simply take it down. So yes, it's a good thing that the DMCA exists for them in that instance.
Right. And how about determining what files are problematic or not? I mean, sort of sticking with our theme here. Do you have any thoughts on that?
Well, you want to have, the point of the DMCA is to take this decision out of the hands of the intermediary, because ordinarily it's too expensive for them to call someone like me each time to evaluate whether this particular model may or may not be copyrightable. And even if I did give an opinion, you still never know when you're going to get a demand letter. I'll give you an example. Not that I would give an example from real life, but just a hypothetical. Let's assume perhaps that someone went to a bunch of museums and took photographs of Stegosaurus skeletons, then went back and created a CAD/CAM file so that someone could print out the skeleton of a Stegosaurus at home. Ordinarily, you'd think that the Stegosaurus skeleton would be in the public domain, because you figure life of the Stegosaurus plus 65 million years. Only Disney can have a term that's long, right? So you'd think it would be out. Nevertheless, I have reason to believe that at least one museum has sent at least one demand letter to one of these file sharing sites asserting copyright in the skeleton of one of their dinosaurs.
In the skeleton as a collective work, or in each individual bone as a sculpture? Well, I'm just trying to understand what they're arguing.
Well, if you were an archaeologist or you worked for a museum, you'd know that you never find a complete skeleton. So you would have to use your expertise to kind of guess at what the missing bones looked like in order to get a complete skeleton. So there's the beginning of an argument of some sort of expert creation. Not that I can see that.
You guys have been to museums, I hope, natural history museums, where they let you watch I'm not sure exactly how accurate the lab that you're able to observe is, but they're in there taking a bunch of bones and putting them together like a puzzle into a skeleton. So,
however,
yes.
Okay, there's actually a circuit court case involved guys who were doing computer models of a car for a car commercial. They were going to do a CGI, and they felt that they were taken advantage of, and they wanted to assert copyright in their wireframe model. And the court said, no, this is the kind of job where even though you have to be really good, and even if you have to be an expert at what you're doing, your goal was verisimilitude. Even if you had to make approximations, you were trying to create something that precisely mimicked reality. So it's not creation. Same here with the bones. If I were involved in something like this, I might argue that to create the missing bones, you were trying to make it look as real and correct, not as creative, but as verisimilitude-ish as possible.
That's hard to prove 65 million years later, though, right? They have no idea what color the dinosaurs were. I suppose
yes.
you could put a medical expert on the stand to say, look, when you have two bones of this type, they have to go together this way. You can't go attach one of them up at the ear. That's not going to work.
Yes. Well, most of the original witnesses are no longer available, I suppose. But if you got the guy who worked for the museum, you'd probably trap them because they're not going to say that they were creative. They did try to get it as correct as possible. So, not a great copyright claim.
Yes. I was just thinking, this is not the same, but it seems related to me to this question of the copyrightability of photographs of real things. So my mind went to the Obama photo and the ferry controversy several years ago, where it was a photo of Obama, and then there was this question of to what extent. So clearly, the photograph has some copyright on it, but to what extent does that protect people from reproducing just a realistic image of Obama? I think that's an interesting. It seems like it kind of borders on that same question of to what extent can you kind of protect real life or something factual because you happen to have a copyright and an expression of it. So
the Obama case really goes to that issue because it points to what we call a thin copyright, where the photographer had to identify where he was standing, the angle that he chose, the lighting that he chose. I mean, certainly there's artistry and creativity, and there was some sort of copyrightable contribution to the image, but the result is what we call a thin copyright. In other words, someone could have been standing right next to him and have a non-infringing work.
Right, absolutely.
Dallas is pointing out in IRC, I think there's an analogy to clean room implementation of BIOS computer code, referring to reverse engineering, I think. Do you see a parallel there, Matt?
Yeah, no, absolutely. I think, having seen the Obama poster and, I could then go to an Obama press conference and, wait for him to strike a similar pose and then take a photo, And even though in some ways I'm attempting to emulate, that very nice photo that was taken originally, the copyright in that kind of photo is so thin that, because I haven't Xeroxed the original, that should not be copyright infringement. It's kind of a shame the Shepard Fairey case never got fully litigated because there are some interesting questions about photographs and, like if I take a photograph of the sunrise, I don't own the sun.
Right.
I don't think so. I think it's really funny in the context of this discussion and I'm glad Dallas brought up BIOS computer code, and we've got, potentially coming before the United States Supreme Court, the Oracle versus Google case where APIs are at issue, that the same darn law that covers photographs and other things that are considered highly artistic also covers code and things that are artistic in the way that they're put together, to be sure, but they have a completely different societal function. Any thoughts on that, Marty?
It's too it's too profound a question that you've just brought up. It's like, there was an awful lot of discussion in the legislative history of the Copyright Act in the 70s about whether there should be a sui generis right. And there are days that I think there should be a sui generis right for copyright. Can
you explain? Everybody just got to drink who's playing the TWiL drinking game because you used a Latin phrase. Can you explain for folks who aren't lawyers or fluent Latin speakers what that means?
The more Latin I use, the more they're able to drink.
They're going to like the
All
show.
right.
The more Latin you use, the better the show gets.
Okay, well, ceteris paribus. I think that might be it for me. All right, so during the 70s, when they were revising the entire Copyright Act, And this wound up with the Copyright Act of 76, which is unfortunately before the era of at least mass market software. There was an awful lot of discussion about it. You framed it exactly the way everyone was perplexed. How can you take something that is supposed to protect the creative expression of the intellect and use it to do something that in some ways, in a way, it's sort of like the verisimilitude problem I was referring to earlier, which is that you're just trying to create this code to solve a technical problem. That is absolutely an overbroad and incorrect way of describing all of the software in the world, but that's what they thought of in the 70s when they're amending the Copyright Act. It's just such a can of worms, and you have the most powerful industry in the world invested in the current regime. I'm like loath to ever open up this can of worms at all and say, look, let's just deal with the present regime, because it's too late to come up with something better. Sorry to be gloomy.
Yeah, no, it's not gloomy. It's just, we have to dance with the one that brung us, right? So that's what we're left with. I want to get into some really interesting copyright pieces that Matt has highlighted recently. But before we go there, we may as well take a break, thank our first sponsor for this episode of This Week in Law, and that is FreshBooks. It's amazing how many lawyers I know spend way too much time practicing paperwork, even in this day and age, and even when paperwork is all electronic, rather than practicing law. On top of their piles or files, computer files of affidavits and case files, there are billable hours that you need to track and expenses to manage and client invoices to prepare and send if you're going to actually have a thriving going concern as a law practice. FreshBooks is here to make your life easier. Now, I am a sole practitioner these days. Used to be involved with a big firm where there were big staffs of people to take care of the accounting and billing functions. But for anyone with a small business who's running lean and mean, you really need a tool like FreshBooks to make it so that you don't have to, number one, worry about making sure that you're able to have a thriving going concern, and number two, have a lot of overhead involved in that process. So what FreshBooks is a super simple cloud accounting software. It gives thousands of lawyers and other business professionals like you the tools that you need to save time billing and get paid faster. FreshBooks lets you create and send super slick invoices online in minutes. You can track your time like never before. You can use your phone so that, as people's lives have shifted over the years. People used to do their work in an office, and they would sit next to them with a piece of paper. And when they were working on one project, they would write down, okay, I spent, 20 minutes working on that. And then they shifted gears. Okay, I'm writing down, I spent 30 minutes working on that. Well, work has really shifted. Oftentimes people are working not in their office, out and about. They're thinking about cases while they're doing other things. And that doesn't mean that you don't need to capture that time and make sure that it's accounted for. So with FreshBooks, you can do that all. Your phone goes with you everywhere, and so does your ability to track and account for your time. Plus, the mobile apps help you organize receipts while you're running around between the office, client meetings, and the courthouse, other places that lawyers and other business professionals go. And if you ever have questions, there's an award-winning FreshBooks support team. The rock stars are waiting for you. There's a real live person on the other end of the phone to help. Getting started is simple and it's totally free for 30 days with no obligation. Go to freshbooks.com/TWiL and don't forget to enter TWiL, TWiL, in the How Did You Hear About Us section. Start your 30-day free trial today. Thank you so much, FreshBooks, for your support of This Week in Law. All right, we've been talking about much of what runs the internet, use and reuse of creative works. Sticking with that theme, I guess we have to talk about Nazis. Because, of course, because the Nazis. Can we talk about the Goebbels estate, Matt, and what's going on with Random House?
Yeah, so this is an incredible case. And it's hard to say, is the problem that we let Nazi war criminals keep their copyright in their journals that they wrote while they were, justifying the Third Reich and committing atrocities? Or is the problem that all this happened a really long time ago and the copyright term is absurdly long? And of course, it's both. But what's happening is Random House is publishing a serious scholarly work talking about Joseph Goebbels, the Nazi propaganda minister. And Goebbels' descendants, not his children, but I guess his niece and grandniece maybe, they own the copyright in everything that he wrote. And they actually enforce that copyright and try and monetize that copyright. And Random House takes the completely credible position that they don't think that money from an academic study should be going to the estate of a war criminal, which is like the least controversial thing Random House has ever said about anything. That is, they're being sued in a court in, I think it's in Munich. The whole thing seems crazy.
What do you think is going to happen?
So German copyright law is not exactly the same as US copyright law. Under US law, again, this would be a pretty easy case for the fair use doctrine. The Europeans don't have a fair use doctrine, but they do have various exemptions for use in scholarly communication and criticism. I just don't know exactly what the result of German law should be. But one thing that's interesting is, the Goebbels estate doesn't need to have a great case in order to effectively license this Nazi copyright. In fact, they've been successfully licensing it for years, I read on the internet. They just assert that they have a copyright, and it's easier for publishers to just pay some kind of clearance fee than to take a large risk or to have a big fight about it. I would commend Random House for their stance here and for not giving in to this kind of terrorism. And on a non-Nazi theme, you have the Sherlock Holmes estate doing the same thing. Well, the Arthur Conan Doyle estate. Just claiming licensing fees for a character who's in the public domain. That's the other side of this story is continued assertion of rights that really don't exist.
Right. That is a real problem. Even though copyright terms are so long, they're apparently not long enough for some. Marty, you want to weigh in on this at all?
Yeah, I blogged the complaint, the Arthur Conan Doyle estate against the movie that's coming out, and I was actually surprised by the facts, and that just reading the complaint, it seemed like a prima facie good pleading. In other words, so the bulk of the Sherlock Holmes stories are in the public domain, which means the character of Sherlock Holmes is going to be in the public domain. However, apparently 10 short stories remain covered by copyright, and those stories allegedly have specific characteristics about Sherlock Holmes, specifically what he was like when he retired. And the allegation is that the new book and the movie based on the book copy those protectable aspects of Sherlock Holmes's character as an old man. On its face, that's a colorable claim, and it's not all that. Oh, look at that good-looking blog. So I'm going to say that when a property partly is in, partly is out, that's not an absurd claim, at least. The other interesting thing, though, is the preservation of what fell out through trademark. So, for example, the word Tarzan is owned as a trademark by the Edgar Rice Burroughs estate, and that creates some sort of issue if you wish to come up with a new movie. And that's why you have some of these movies have such bizarre titles. Dracula by Bram Stoker is a title of the remake, the Gary Oldman remake of Dracula, because someone had rights in Dracula as a trademark. Yes, there is an attempt to use trademark to make copyright protection eternal, and yes, there are ways around it.
All right. I'm so glad Virgil mentioned this in chat because it allows me to highlight the headline, "The Umpire Strikes Back. Who's on first? Lawyers bat around Broadway's Hand to God case." So apparently what we've been discussing here is there is a play called Hand to God, a musical. I'm not familiar with it, haven't seen it, but it uses the iconic Who's on First, Abbott and Costello comedy routine. And the heirs of Abbott and Costello are suing for copyright violation. So this goes on in any number of ways. Have you heard of this case, Matt?
No, I haven't.
So, yeah, we'll have to see if they make some similar creative arguments, Marty.
Look, the routine is ceteris paribus. The routine is protectable. I mean, it's very specific, and allegedly this character that you're showing does that routine. So again, unfortunately, or fortunately, it sounds like a colorable copyright claim.
Right. Okay. What else shall we touch on before we shift gears into some related but slightly different topics? I think we should touch on the Prenda law attorneys. These guys have paid so much in sanctions now, it's almost not news when they're ordered to pay an additional $65,000. But Matt, maybe you can bring us up to speed on this latest sanctions award and what it triggered it exactly.
Yeah, so it is honestly hard to keep up. I mean, Prenda, obviously, they're the early adopters in copyright trolling and specializing in pornography. I think in this case, they were being intentionally obstructive in some kind of discovery request. And I believe this is also related to attempts to hide money to not pay other sanctions awards. So, like when the tide turned on Prenda, it really turned full scale. But we should remember, I mean, these guys made a lot of money back in the day. So, even though they keep getting fined, they still could be ahead.
Yeah, that's a sad statement, but true. Yeah. All right, I'm feeling a little musical, so let's shift gears and talk about fair use in that context. So I think this is a thing. Somebody sent me a link to a particular video where 80 plus songs, very sort of current popular songs, were mashed together and wanted to discuss the copyright ramifications of that. I don't think this is I don't think this is the only one of these videos here. We're playing a bit of it now. Little audio there. So obviously there's some talented mixing going on to put all this together. And like I said, it's fun to say, I recognize that Taylor Swift ditty alongside Katy Perry and whoever else. But, the copyright ramifications of doing something like this are far from clear. And the question I got about this was, well, how can this even exist? I'll throw that out to the panel. What do you think about, Matt? Is this the next video to get taken down from YouTube, or have we gotten to the point where mashups are more an accepted and legal part of the culture?
I think that we're becoming more comfortable with mashups. I took a look at this video. I think that it's definitely, it's walking up to the line. I think, in my view, it's on the correct side of the line. And the real test is when you listen to it and watch it, is it fulfilling your demand to see Katy Perry and Taylor Swift, or to listen to them, or is it communicating something else? And everything's so brief and so fragmentary, and the real, the art of the video is the way it's all stitched together. Like some of the art cases we've talked about, like this is one where, the fair use doctrine gives the creator of the mashup the ability, it gives them the forum to explain why what they are doing is fair. And I would say that it is fair. If they'd taken a lot longer snippets, then they'd probably be on, the other side of the line. But I think the real issue is not fair use at all, because, as we know, it doesn't really matter whether it's fair use or not. It matters whether someone's going to issue a takedown notice.
Right.
So, that's the interesting thing, is actually, maybe fair use doesn't matter so much online, which is terrible for me because I've written like a dozen articles on the fair use doctrine. But maybe what really matters is how people are using the DMCA. Right, because I know nothing about the artist who put this together, but I imagine that if a record label decided to say, nope, there's a 3-second clip from our artist in that video, and you need to take it down, that they're probably not going to be able to fight that, even though technically under the DMCA they can. Marty, any thoughts?
So my favorite artist is Girl Talk, and I want all of your listeners to go to Girl Talk's website right now, and I want you to download at least the last 2 albums, which is Feed the Animal and All Day. In addition to Girl Talk, there's White Panda. Coincidentally, I listened to White Panda all this morning, not knowing this was going to be on the show. An artist named E603, who was a Girl Talk fan, took the same songs that Girl Talk had mashed up and attempted his own mashup. And although it wasn't horrible, it was nowhere good in comparison to Girl Talk, which convinces me that there's good mashups and bad mashups. There is an art to doing it. Now, as a copyright lawyer, I would advise Girl Talk to continue to hide his true identity. And actually, you could follow Greg Gillis of Girl Talk on Twitter, and I recommend that you do. And we're all waiting for his next release. But the reality is that he does 30, 45-second bits. And in a world where the Sixth Circuit believes that there is no minimum amount that you could sample lawfully, strictly speaking, Girl Talk could have some exposure. As a consumer, I love his stuff. I would pay for his stuff. But I think that he's not selling. You can download all of his stuff for free on his website, and I think that's part of some kind of deal to keep him out of prison. Because sadly, I mean, I think, although I believe he transforms everything he touches, it's not fair use as we understand that term.
He's the anti-Richard Prince, right? He's not charging $90,000 or anything like it for his art. Sarah, any gloss you can add to this? It would be nice if Creative Commons existed as to every piece of music available, so that mashup artists could have a broader base from which to draw and not have to worry about concealing their identities or giving everything away for free.
Yeah, I mean, I would definitely like to see that world. Or maybe even better is to take out non-commercial uses from the scope of copyright law completely, so that if you're not making money off something, you can do what you want with it. I don't necessarily see that happening, though. I think what's really interesting about comparing the sampling, the state of the law with sampling versus fair use in the context of what Prince is doing with photography is, to me, there's a lot of inconsistency there. I don't see why the kind of using music as raw material, why that same argument doesn't fly in the sampling context. I think there's a lot of inconsistency there. Because really what as Marty was just saying, they're making something new and different and transformative. It just happens to be music, not photography. And I don't really understand why there should be a legal difference there.
Yeah, I'd love to hear our law professor on the panel's take on that. Why, over time, as the law has developed, have certain creative works garnered one level of protection and others another?
Yeah, I mean, in theory, it's the same law, but, like it turns out it's not. And it's partly because the music business has been very aggressive in pushing a sort of, a no sampling line. But it's also partly because, a lot of the value in music can really be appreciated in very short bursts. I mean, like 30 seconds of a song, as opposed to 5 lines of a novel, they take about the same time to experience, but they just have very different implications. Maybe if I hear 30 seconds of a song, I don't want to go into iTunes and download the full song. So, I think, the Sixth Circuit's position that there's no sample too small is just obviously wrong. But, it is a different context. And I think, to me, one of the real problems is the music licensing market is so dysfunctional. Like, if you actually want to get a sampling license, good luck. You need lawyers, you need connections, you need years of your life. And then, if you can get one person to agree, they're going to want 25% of your revenue. And of course, try doing that 5 times over and it just doesn't work. So, yeah, it seems like our legal system, it copes very well with text. It doesn't cope so well with images because it's hard to sample an image unless you're literally cutting out bits of it. It doesn't seem to cope so well with music either.
Mm-hmm. I think one of the things that you're kind of alluding to here is completely right, is that one of the big differences from like the Prince context and this one is whether or not the artists are well known. So a lot of the music being sampled are by, it's very famous music that has an existing kind of meaning in culture versus, these random people on Instagram whose photos are being co-opted. And query whether or not that should actually be, to me, I think there is some legitimate reason to distinguish those two, because you could argue that if you're using something famous in your own work, then you're kind of drawing on the fame in order to boost your own work. But on the other hand, it really does kind of put the average person's work, it's somewhere, at an unfair advantage in that sense, because it can be reused in ways that if you're famous, that it can be. So it's kind of interesting. I don't know if you were getting at the distinction, but I think that's kind of, inferred from what you said.
Yeah, in the Second Circuit's opinion on the Richard Prince case, there's an extended discussion about how famous Richard Prince is and that, his artwork is owned by people like Jay-Z. And it's actually a little disturbing how impressed the Second Circuit was with how famous Richard Prince is. I understand that they were trying to say, look, appropriation art is legitimate and it's important. But at times the decision read as though, well, here's a photographer who wasn't a commercial success, and sure, he spent 6 years in the jungle taking photographs that are in this book, and the photographs are actually kind of cool. But Richard Prince is famous, so he can reuse them in an art exhibition. And I think that rubbed a lot of people the wrong way. That's not the way the law should work. You own the copyright on your works on Instagram, and if someone's going to use them, transformatively, then that's fine. But the fact that they're rich and famous and you're not doesn't automatically mean what they do is transformative. But yeah, in the context of the music business, I think the rights owners are much they're vigilant and assertive, and the materials people want to remix are not obscure. The materials people want to remix, they want to play with our everyday culture. And I think, in some ways that makes their case stronger because, they're sort of playing in our communal culture. But it makes the legal obstacles more formidable because, the record labels are vigilant, to say the least.
Right.
Yeah, there's sort of a sauce for the goose, sauce for the gander kind of logic to all this that I'm not sure if it actually holds true. That I think, Sarah, there is a tendency to devalue, even though the copyright law doesn't expressly do it, the works of a more obscure artist than the works of popular artists. So getting back to the mashup situation, Marty, you could see why the labels involved in this 80-plus song things or in some of your girl talk mashups might jump on that notion of, hey, you're coattailing along on our fame to make your work appealing and popular. And it's almost, in this 80-plus songs video, it's almost as though you had the opportunity to have all these great artists together performing, making one great work themselves, but none of them have actually been involved in that. And I could see, why they and their labels would take exception to someone putting together a virtual performance that they don't actually have a say in, get to profit from. It's far better than than the actual performances that you see, right? When you get them all together on stage and they're singing "We Are the World," and it's just kind of awful. But in this context, it works. So Marty, if this was just a bunch of not famous musicians who were put together and packaged in this way, do you think it would change a court's approach?
There's an argument to be made that part of the power of Girl Talk Smash Up or something like that is that these hooks are recognizable. So in that sense, he is borrowing some of the creative accomplishments of the underlying work. So that is a fair argument that the copyright owner can make. And yes, a mashup of totally unknown pieces would have a greater challenge at being recognized. I mean, I liked Girl Talk at first, maybe the first listen, because of the recognition of certain hooks. So yes, that's an absolutely fair argument that they're piggybacking on pre-existing copyrightable creations.
Right. Well, let's make Girl Talk our first MCLE passphrase for this episode of This Week in Law. We put these phrases in the show. If you are a lawyer or other professional who needs to earn professional credit, educational credit in your field, we have wonderful scholars on our show, such as Matt and other experts in the fields that we talk about. And we think the show's pretty educational and interesting. So if you too like to listen and you need to meet these educational requirements, we have some information for you over at the TWiT wiki at wiki.twit.tv. Find our This Week in Law page there. And if you're a lawyer, there's a breakdown of all the jurisdictions in the United States and how one would go about applying for credit. So hope that's going well for people who are doing that. And we'll put another phrase in later in the show so that you can demonstrate that you actually watched or listened. Let's see. Apple is attempting to compete with things like Spotify, I think sort of directly taking on Spotify head on, and a bit of a Pandora gloss too, in putting together a more curated listening experience for those who prefer that, as opposed to putting together their own mixes of music. And I guess the notable thing here, there are a couple of notable things. First of all, sort of the weak response that people have given the announcements from the Worldwide Developer Conference from Apple about their new music plans. And secondly, Wired pulled out, there is an interesting pricing aspect of this. John Gravois over at Wired points out that talking about the way people consume music today and how far we've come from the days when, you know, you weren't able to share any kind of file because that would be a violation and somehow depriving the artist or the rights holder of another ring in the cash register for every listen of that file. Apple's streaming service is going to have a family plan option. I don't know how many people are using the iCloud family sharing. We just recently set that up and it seems to work pretty well. But they're going to integrate that with family sharing. So it's slightly more than Spotify, $15 a month, you'll be able to share an Apple Music account among as many as 6 people. And of course, that doesn't necessarily mean that all of those 6 people have to be DNA related to you. So I thought I'd just toss this out, see if anybody thinks that Apple's going to be a big force in combating the other music moguls that are out there. And it's kind of funny to reflect on how, you know, Apple back in the day was the way you listened to digitally distributed music. And I just don't think that's the case anymore. And so much so that they're actually, and this is in your wheelhouse, Matt, getting investigated for antitrust violations in the deals that they've cut with record labels in being able to carry and price their music as they do. So, Matt, what do you think of Apple's new plans?
I think, it's interesting. We've been hearing about this for so long, and we've known about it, their plans for so long, that the announcement was a little bit anticlimactic. In terms of the antitrust or the competition law case, I don't think that all the facts are in, but certainly the allegation is that Apple is leaning on the music players to stop facilitating ad-supported streaming. Now, in particular on Spotify, they actually, they can't not support Pandora because Pandora has a statutory license. But Apple thinks it can compete with Spotify, but it doesn't want to offer an ad-based version. And so it's alleged, at least, that Apple has leaned on the music companies to not support the ad-based version on Spotify. And if that's true, I think that could well be an antitrust violation. You typically, you don't get to lean on your suppliers and tell them whether or how they can sell to your competitors. It's a little disappointing that the Apple service, I have Spotify and I quite like it, and I can't really see any reason to change to the Apple service. And I think, that's why people are a little underwhelmed. They're expecting, it'll be like Spotify, but with something else. And there wasn't really anything else.
Mm-hmm. Further down in that Wired article is an actual economic breakdown just doing the math, right? You're paying $14.99 a month. If you have 6 people, that winds up being just $250 a head per month for the Apple Music service. So that is, even if they're not able to undercut on the original pricing, if enough people to get together and take advantage of this family plan option, they're giving consumers a way to do it that way. Marty, any thoughts?
Everyone in my family only listens to Girl Talk, so.
It's all free. That's awesome. Sarah?
I guess I felt the same as Matt. It was hard for me to see what differentiates this plan from Spotify, other than, I guess, the family plan. But for me, I don't pay for Spotify. I use the free service anyway. One thing I thought was interesting in one of those articles, it was talking about how Apple is trying to position itself as a platform for smaller artists, which I thought was kind of fascinating and maybe a reflection of what kind of happened with the TIDAL flop. I don't know if it's still a flop, but there are all those headlines about TIDAL kind of petering out after the initial splash because they had kind of tried to use the whole, artists are starving argument, but then the people that they held up were really famous, really, rich artists. And so it seems like maybe Apple's communications or PR here is kind of a reaction to that. I thought that was interesting.
Yeah. I think the one thing that Apple might be able to improve is kind of the curation, like making lists and actually helping you find the music that you want to listen to, because there's a lot of music out there. The challenge is always finding new material that you'll enjoy. So perhaps if Apple can do that better, that would justify the switch. Like Apple still hasn't quite recovered from the ebooks antitrust litigation. Clearly they're happy to keep their lawyers busy.
Yes, they do seem that way.
I have a question for
Marty.
the group.
Sure.
This is a topic for another day. There's reports now that there are radio receivers in everybody's smartphones, but that the cell phone companies don't activate the radio receivers. So you could have radio in your smartphone all the time, but they don't let you. Have you heard these are reported allegations. I heard it.
Yeah, this is not the first I've heard of that. So are you suggesting that maybe this is some sort of nefarious music industry back dealings with the cellular carriers? That, they don't want another way for radio to be delivered?
I would never accuse a copyright industry or a telecommunications company of doing something for money. Draw your own conclusions.
Yeah, I don't know.
I don't know. Secret radio receivers in our phones, are they like the ones that are in our teeth?
Yes.
No,
very like.
There really are. They're not secret. There are radio receivers in your phones. I would suggest that you'd open yours up and check right now, but I don't know if you could close it afterwards. So no.
Yeah. Yeah, that's the problem, right? We can't get into and look at our devices anymore that easily. Let's move on, Marty. We were talking about sauce for the goose and sauce for the gander. I don't know of a better example of making you think about the same issue in different lights than the slants case. So that obviously involves trademarks. So we've talked about the slants case a couple of times on the show recently. It's super interesting, and we're going to learn more when the federal circuit tells us more. But Marty, this is really your expertise, and you've actually been having an interesting Twitter back and forth with the band's frontman, correct?
Yeah, well, last night when I was saying on my Twitter handle, @trademarkblog, that I was going to be on the show and talking about the slants case, a member of the Slants responded and started talking to me on Twitter about the case. And I gave him my idea, my theory I basically took his side. And I can tie it in conceptually to our prior conversation about...
Okay, before you do that, I don't mean to derail you when you're on a roll, but for folks who have not tuned into our prior episodes where we've discussed the case, who are the Slants and why is their trademark an issue?
Here's the issue. So the Lanham Act, the federal trademark statute, prohibits the registration of trademarks that are, among other things, immoral, scandalous, or disparaging. Now, the important thing that I just said is that it bans the registration of these trademarks, not the use of these trademarks, because if they prohibited the use of these terms, then it seems to be on its face an infringement of the First Amendment. Over the years, most of the cases usually are involving dirty words. We could all have a laugh reading some of the words that have been banned or not denied registration. Now, there are two high-profile cases now, one of them involving the Redskins trademark and one of them involving the trademark The Slants, which is the name for a band. And in the case of the Slants, they wanted to obtain registration and they were denied. There was an appeal. The Trademark Trial and Appeal Board, the administrative body of the Trademark Office, rejected the application for the Slants. They appealed to the CAFC, and the CAFC affirmed the rejection. However, there was another opinion in the case. It wasn't a concurrence. It was just called additional remarks. And Judge Moore of the CAFC said, in effect, this ban on registration of these scandalous or disparaging terms is unconstitutional. So the CAFC vacated the decision, and they're going to hear it en banc. And I think that they are teeing it up to find this provision unconstitutional, which is interesting to the Slants and very interesting to the Redskins. The part of the case that can be of interest to your audience, and what we talked about last night with the Slants, was the reclamation argument. And that kind of ties into our discussion of fair use and whether the artist is rich or not. It kind of suggests that when we're interested in what the use of a symbol means, it may very well matter who's saying it and in what context. It's difficult for a court to interpret, but it may be the best analysis we can do. So there have been marks where it seems apparent that the applicant does wish to disparage a group. And I did a trademark search of the word queer last night, and there are absolutely applications that seem on their face to be disparaging of homosexuals. However, about 10 years ago, there was an application for the mark Dykes on Bikes. And the applicant was a women's motorcycling group, and they held organizations for advocacy of motorcycle races called Dykes on Bikes. And it was the application was initially rejected. And their attorney made one of the most eloquent briefs that I've ever read of what I would call the reclamation argument, which is that when the group that has been disparaged is the one using the term, they reclaim it. And that argument was made, and that argument won. And Dykes on Bikes was published as an application. Now it's a registered trademark.
And I'm sure someone just brought this up in the IRC Reverb. Mike did. I'm sure that the very successful show Queer Eye for the Straight Guy was able to get a trademark on their brand.
Absolutely. Queer Eye. Part of this, another aspect of this is how we think of terms changes over time. Queer Eye for the Straight Guy is a registered trademark and did not even receive an objection. It came slightly after Dykes on Bikes. But yes, Queer Eye for the Straight Guy is a registered trademark. And I think it is a demonstration of what I think is like a psychological or sociological principle that it's not disparaging depending on who uses it. Now, I think it's the case of the Slants. I mean, I don't think we've actually said it, but the Slants is an Asian American band. And they absolutely, in their music and in their conversation, discuss that one of their points is to combat anti-Asian stereotypes. So, however, in the CAFC case, they say the test is whether it is disparaging. They don't say that the test is whether this particular applicant is using it to disparage, which I think ought to be the test. So I'll leave it for now, let you guys do some talking, but this is where we stand with regards to this application. I guess I should set up the constitutional issue.
It's a speech issue.
So the government can, when there's like a fiscal benefit, assert conditions. If we're going to give you this grant, you have to do this, this, and this, and that may or may not impinge upon your constitutional rights. What it can't do is just withhold a right based on speech. There's only been one case, apparently, not even a Supreme Court case, a CAFC case, that said that this provision of the Lanham Act, it's constitutional because it doesn't keep the applicant from using the mark. It's just withholding this particular benefit. And Justice Moore is now saying, no. The government cannot withhold a non-monetary benefit based on speech. So they've teed it up, I think, to find this provision unconstitutional.
Got it. So getting back to our sauce for the goose, sauce for the gander point, and you mentioned this, Marty, that the Washington Redskins have been told that they may not have their trademark. So, Matt, do you think that determination will be affected by the Federal Circuit's ruling when they rule en banc on the issue related to this band?
Well, it depends how broadly or narrowly the Federal Circuit rules. I mean, if they say that the provision is unconstitutional, then obviously that's good news for the Redskins. They don't need to go that far. I mean, they could just rule the same way that the appeals board in the Dykes on Bikes case ruled, and just show a little more nuance and understand that you always have to look at the context in which a label is used, and if an Asian American band is trying to reclaim the word slants, then good luck to them. We should all be with them. The Redskins can't make that kind of argument. The Redskins case has been litigated for I think the last 15 years. You have to imagine one day it might go to the Supreme Court. So maybe these cases could go up together. I'm not terribly convinced by the First Amendment argument. I don't think that it's an unconstitutional condition under that doctrine. But I think I honestly have no idea what the court's going to do with it.
Yeah, it'll be fascinating. And I thought I'd just sort of step back from this discussion. And if anybody is wondering, why the heck are they discussing this sort of esoteric trademark issue on this show that is about technology law, or so they always say it is? And my justification for paying attention to these kinds of issues is because the web, which is the basis for so many of the issues we discuss on the show, is in large part driven by people's trademarks. That's how we get around. That's how your search terms, that's how you search for something and find something. That's how you have a domain. So trademarks are pretty integral to the way we navigate the web, and that's why I feel like we can get into whether the slants can call themselves the slants or the Redskins can call themselves the Redskins. Sarah, were you going to say something?
Sure. I mean, I was going to say, I guess, that the reclamation argument that Marty articulated makes a lot of sense to me. I guess personally, I like that argument, but I wonder about whether or not it has any effect on the First Amendment argument. Just reading Eugene Bullock's piece that you put in the rundown, he talks about how the government can impose content-based limits, but not viewpoint-based ones when it comes to giving out, benefits like this. And it seems to me that if you allowed, some groups to use them and some groups not to, in terms of like favoring one or the other, maybe that would even make the speech argument even worse. But I don't know if that's true. But that just occurred to me as we were talking about this. I don't know much about First Amendment and what the actual standard is. So if anyone else does, please speak up, because I might be misspeaking here.
In the CAFC case, the slants made the argument that there's an equal protection problem. They said, hey, listen, other people could have come and filed for the slants for pairs and there wouldn't have been no problem. It's because we're Asian and we're filing for the slants that you put two and two together, and therefore we are a group. You're looking at us. And you're saying no, and that's actually not quite the way I would have argued the constitutional challenge to this, and that was struck out. But you understand why it's troubling when you say, hey, this group will be allowed this benefit and this group won't. And on its face, that's a question that has to be answered. However, in trademark law, we're always looking at who is saying it and what they're saying it about, and that the Trademark Office's business is making these difficult case-by-case determinations. Oh, this guy is a thermos provider. Well, he could have used that mark thermos for underwear, but he cannot use it for vacuum bottles. So we're always looking at who's doing the talking and what they're talking about. There was another case where Pamela Geller, you should pardon the expression, filed for the mark Stop the Islamification of America. And that was found to be disparaging because, among other things, she cited the services as stopping terrorism, which, I don't know, unusual services. How do you get that? But in any event, yes, I mean, the reclamation argument, I just think it's sociologically correct that who the speaker is determines the interpretation of the speech, which is a point that may be too subtle. It's certainly too subtle for racists. There is a T-shirt that you can buy on the internet that says it's a black T-shirt and says, "This is a black T-shirt." It can say the N-word. Right. So, but I just think it's a cognitive psychological fact that we interpret things based on who the speaker is, and that can determine what is disparaging and what is not. Okay.
Yeah, I completely agree with you on that. I just wonder whether or not people that are making the argument that this is a First Amendment issue, whether or not that would fly. Because if you argue that excluding marks that disparage groups while allowing marks that praise those groups, if that in itself is viewpoint discrimination, then it seems like allowing some groups to use it and others not would just would just further that, I guess. I don't know if I'm articulating that correctly, but I completely agree with you on a sociological level that makes perfect sense, the reclamation argument.
The CAFC case, which we put in the show notes, both the majority and the additional remarks are really well written. And I really encourage you guys to go out and read that case, if for no other reason how justices in the same room hearing the same evidence and discussing the same case can come out very different on the entire view of the world on this statute. So, I mean, more eloquent than me, go look, the CAFC case, go read it now.
Okay.
But listen to Girl Talk while you're reading it.
We're going to make reclamation our second MCLE passphrase for the show based on this argument. And in a moment here, I want to get into a case that will demonstrate concretely why we talk about trademarks on a technology law-oriented show. We're going to talk about keyword advertising in a moment. But before we get to that, I'd like to thank our second sponsor for this episode of This Week in Law. As you're going to have a delicious bite, you might as well consider having one from Blue Apron, because they are particularly delicious and healthy and quick to prepare and a great value. And who doesn't love a meal that's all of those things? And one that has not required you to go to the grocery store and load up on stuff before you go ahead and prepare it. Instead, it comes right to your door. And it comes with fresh, delicious ingredients. It comes perfectly proportioned so that you know that you've got exactly enough onion and asparagus and everything else that you need, and that you're not going to have leftover asparagus going wilty in your fridge when you're done making the meal. You have also wonderful, wonderful opportunity to have a family event here, because they come with these great recipe cards, very clear instructions. If you've never cooked a day in your life, they're not going to expect you to know a whole lot of cooking jargon. They're going to explain to you exactly what they mean by julienne. Slice it up really thin and small. I'm paraphrasing, but they give you really nicely clear instructions. So if you've never picked up a knife before, or really are not the family saucier, you're still going to be able to put this together. So it's great to, put the kids to work, give them the wonderfully proportioned ingredients and the instructions, and, with a little safety oversight, make sure that they're checked out on the oven and stove and cutlery, and then turn them loose, let them cook you dinner for a change. And it's less than $10 a meal for these wonderful experiences. Perfect for date night, cooking with friends, cooking with your children, and perfect for just staying in instead of going out and having a night on the town. Sometimes it's just great to have your family and friends around the table in your own home, and to do it without having to slave away in the kitchen for hours beforehand. They're going to work around your schedule and your dietary preferences. Blue Apron's experts source only the best seasonal ingredients and really put together wonderful flavors and spices, sometimes some really esoteric and exotic. I hate to use the word exotic, but it comes to mind when I get some of these spices that I've never heard of, and then put together into these great meals like salmon burgers with creme fraiche sauce and potato salad, or 3-cheese calzones. You'll cook incredible meals and be blown away by the quality and freshness. Blue Apron, it's a better way to cook. Check out this week's menu and get your first 2 meals absolutely free by going to blueapron.com/twit. That's right, 2 free meals just by going to blueapron.com/twit. Thank you so much, Blue Apron, for your support of This Week in Law. All right, Marty. So well, first of all, we should explain the problem for people who are not familiar with the fact that there has been sort of an ongoing cat and mouse over the years between people who have trademarks and want to be found on the web through people doing searches for them, and others who have wisely discerned that, hey, I'm a competitor of that company, or I'm someone who might benefit if that company's business is going awry. And so I want to have my company's website come up when someone is searching for company A. Competitive keyword advertising is the phenomenon that we've been going around here. And there's a recent case that Professor Goldman says is the last remaining lawsuit over competitive keyword advertising. Marty, do you agree? Is this phenomenon now just completely wide open? And there were some cases early on that thought that maybe we could put a stop to this practice, but no?
I think I concur with Professor Goldman's view that this is the last case. And I think that this is an example of a phenomena that, as we get used to the internet, we perceive things differently. 15 years ago, clients got bent out of shape if someone had purchased their keyword and was using it to advertise competitive goods. I think 15 years ago also, if you were driving to the Toyota dealership and on the way you passed a Honda billboard, if you changed the direction of your car and went to the Honda dealership instead, I don't think Toyota had a cause of action. But essentially, this is what people were doing in the early days of the internet. I think that trademark owners have gotten used to it. I think that Google sort of enforced the most egregiously misleading ads. And I think that internet users understand now that if they put in Honda as a key term and they see ads for Toyota, that they're not confused as to source, and it's not really a cause of action. So it's an example of you live and learn. The perception is different. There's no confusion. I think that keyword litigation is a thing of the past, so I'll have to find a way to make a living some other way.
It reminds me of our earlier discussion about the folks who are bent out of shape that Richard Prince has used and profited from using to a great extent. Their Instagram photos, that there was this sentiment that, hey, I have that trademark and I'm the one who gets to use that trademark to promote my business, and you shouldn't get to use my trademark to promote yours. So do you think we have a parallel situation where maybe as people get more used to how the internet works over time and more used to how it means to have your own creative works on the internet, that a similar thing might happen, Marty?
Well, I'd like to believe that the process of learning is going to occur. Yes, I think when we have a brand new application on the internet, we are always a little hesitant. We don't know what the deal is. I think that it's a case-by-case basis. I think when Twitter handles were first being allocated, for want of a better word, if someone were to get my trademark, I would worry that people are going to assume that it's official. Paradoxically, as you get further in and the large companies discover Twitter, it becomes more and more likely that at Honda or at Toyota are owned by those people. So maybe I've just contradicted myself by giving a counterexample. Whereas people become more accustomed to a specific application, they perceive things in a different way.
Mm-hmm. Matt, what do you think about keyword advertising and the parallel I was drawing before?
Yeah, so I think there's an interesting evolution with keyword advertising. If you go back to some of the trademark cases that were decided in, say 2000, the judges are like, oh, there's this thing called the internet, and it's a system of tubes, and it's its own market, and it has nothing to do with the rest of the world. When I teach one of those cases, my students just kind of snigger. I think the courts have learned how the internet works at the same time as consumers have learned how the internet works. And so things that might have been confusing 15 years ago, consumers just understand, oh no, that's a choice. That's a competitor. They're saying I can have a Big Mac or, a Royale with cheese or whatever. So I just blanked on the name of the other hamburger. The Whopper. There we go.
There you go.
So I think consumers have got smarter and courts have got smarter and have understood that consumers are smarter. And so these trademark cases, it's just really tough to show confusion. Like if the copy of the ad is not itself misleading, telling someone who's looking for a Honda that they might appreciate, a Ford Explorer. That's just more information. Maybe we should talk about ad blocking software as well. Maybe this is why we're not going to see any more keyword ad cases.
Right. Well, expand on that. I mean, do you think that ad blocking software factors into people's acceptance of people using others' trademarks competitively?
I just think that, like, the business of this sort of clearly delineated sidebar advertising might be coming to an end. I think that more and more people are using ad blocking software, as ads become more intrusive, that fewer of us are going to be seeing them. So the keyword advertising is not going to be the big issue. The big issue is going to be, truly integrated product advertising. So, on my Instagram account, sometimes I see things in my feed that just look like a cool photo, but if you think about them carefully, they're actually an ad. So, I think, the whole advertising paradigm of the internet might be about, undergoing a pretty radical change. And if that's the case, then keyword advertising is just going to be a historical footnote.
Right. And I guess the footnote to that comment is that ad blocking software, first of all, has to get more widespread among people who use the web on their desktops. But then we need, in order for all that to play out, we also need it to be available, let alone widely available on mobile devices as well. I don't know how you ad block on an iPhone. Educate me if you can. I'd like to, if I can.
So I think, and we should fact check this, but I think Apple just announced that they're going to integrate ad blocking into mobile. And there was a lot of, there were articles about, what is this going to mean for content creators and things, but we should dig into that more. But I think that is actually on the horizon.
Yeah,
let's bookmark that.
I read a story about this just yesterday, and I'm not, perhaps don't have all the details, but if say Apple or Google are controlling the ad blocking software on Android and iOS, that gives them some pretty interesting gateway power to decide which ads go through and which ones don't.
Right.
And, it potentially makes net neutrality rules even more important. It's very difficult to see how this will play out, but just as the sort of desktop to mobile was an important paradigm shift for advertising, I think dealing with this software is going to be an important paradigm shift. Which I know we've strayed well from the topic of keyword advertising.
It's really fascinating, though. The evolution of advertising in general, I think, is a fascinating topic. And again, another instance of cat and mouse. Nobody wants to get ads, but I think everybody recognizes that a lot of the services that we receive would not be possible without them. Going back all the way to the, how revolutionary it was to be able to skip ads with a TiVo back when they first came around. And who were the other people who went bankrupt, Marty? You'll remember this. Not TiVo, but was it Replay TV?
Yes, they went bankrupt. Yeah. I'm reminded when TiVo came out, I don't remember which TV executive, someone said that consumers had this implicit contract with the networks to watch the commercials and that they were watching it. So I wonder if now, somebody will say that web users have an implicit contract to not use ad blocking software.
Yeah, it could make that parallel. All right. Marty, I'm asking you this question in honor of our wonderful intern, Sando, who let me know another announcement from the Worldwide Developer Conference from Apple. is that it has decided to do a bit of rebranding. Instead of Passbook, which it's still calling its Passbook feature, they're going to call it Wallet. They've integrated credit cards with that thing, and it's working as a pay system, so it will directly compete with Google Wallet. And my intern's question was, is this a problem? We were talking about something that is a very, very generic term, but because Google has a wallet first, does that somehow hinder Apple from having one that functions similarly?
If they're the second comer, they're going to have to make the argument that wallet is a generic term for any kind of thing like this. For years, I was thinking that they were going to use e-wallet, and I would search for it, and there was just too many people who'd filed for e-wallet. You'll also notice that they're going to an Apple plus generic branding scheme with the Apple Watch as opposed to the iWatch or the eWatch or whatever.
Right.
So it's we should all have Apple's branding problems.
Yes, we should. And we should all have Matt's problem recollecting the appropriate burger. I was thinking at the time, Matt, when you spaced there for a moment, it's just your brain is wired more Pulp Fiction than Burger King, and that can be a bad thing. So let's move on to our resource and tip of the week. We'll start with the resource, which is a wonderful paper and summary of a paper by Matt called The Prehistory of Fair Use. And it gets into how we got to where we are with the fair use doctrine. And it dispels the notion that it began with early American cases, and in fact pulls out some very nice language from a 1741 case in England called, is it Giles versus Wilcox? We could have the GIF discussion about Giles or Giles versus Wilcox. Do you know exactly what was involved in that case, Matt?
Oh, yeah. So Giles versus Wilcox was a case about a law textbook. Actually, like one of the most important law textbooks at the time. It was Sir Matthew Hale's Pleas of the Crown, which was had actually been written a long time previous to the case, and it was reprinted in an abridged version that essentially cut out some of the commentary and translated all the Latin back into English. The defendant was sued for copyright infringement under what was then a really new statute, the Statute of Anne, which is the first Copyright Act. And the decision doesn't say equivocally, well, this is or is not copyright infringement. It says, well, whether this is copyright infringement depends on, is this just, is it a new work? Does it show, new learning and new authorship, or, is it really just a copy, disguised copy of the original? And I think, so two really important things come out of this case is, the judge looks at the language of the statute that doesn't say anything about abridgment. It talks about books and vending books and reprints, and says, well, I'm not going to read the act strictly and literally. I'm going to read it broadly and purposively. So that's, expanding copyright. But then, at the same time, the judge says, but this is, it depends whether it's a real and fair abridgment, which in some ways is, narrowing copyright. It's the precursor to the fair use doctrine. And, my point is, one, both these things happen at the same time. This is all about reading copyright in a purposive way to try and keep copyright, consistent with the reasons that it was created for. And my second point is, it happens 100 years earlier than most people think.
Right.
It happens in England, almost at the beginning of statutory copyright.
I'm picturing how Girl Talk would have flown in 1741 London.
Girl Talk would have been fine.
Yes. The invention, learning, and judgment of the author are shewn in it. And in many cases, abridgments are extremely useful. I think Marty would agree, right?
I'm just trying to envision Girl Talk functioning without synthesizers and,
Yes, I'm sure that he'd find a way.
I think it would all be done on a lute.
Exactly.
A lute loop.
Yep. Mm-hmm. Lute-based mashups. Don't laugh. Someone will do it. Or probably already has done. All right, let's move on to our tip of the week. Our tip of the week is I'll step back and say I'm sure everyone has noticed, and there may even be a name for it now because it's such a phenomenon, the trend of how different websites look today, and just in the last maybe year and a half than they did previously. Websites have large pictures behind them now. I guess this is because bandwidth has increased globally to the extent where people feel like they can put up a website that has enormous graphics and it can still load nicely on people's devices. So we have these large background pictures, but then everything else very clean, and all the news sites have, the huge graphic at the top and then scrolling down below that with even more huge graphics. I don't know. It's just a totally different look, and there's probably a name for it that I'm just unaware of. IRC will put me on the right track if there is. But I think that TWiL will be right in line with this trend when we relaunch our website. Leo's been giving some hints of what might be coming for the new twit.tv website. It's very pretty and clean, and also incorporates great big graphics. So in keeping with this, although I will say I'm wondering if we will look back 10 years from now at this large graphics on our websites trend and look at it like the Angel Fire sites way back in the day, that everyone was doing this and it looks perhaps a little silly. This is my tip for how to do a law firm website, adopting this new trend. It's obviously right in line with that. Zombie Law at injuredbyazombie.com. This is, I believe, a real law firm website that just has decided to put up a delightful website. And when you go to the About Us page, you have actual information about what appear to be actual lawyers, although they do have language like, in general, hordes are kept to a minimum and we schedule living and ex-living clients on opposite days for your comfort and convenience. So I am not going to say 100% this is real, but I think it is. And I just love it. I think it's a beautiful site, and has all their information available. They do say they have locations in every state of the continental U.S., which leads me to believe maybe this is more of a hoax than not a one-off. But if anyone figures this out, do let me know. I do love the site. I think it's a lovely example of the trend that I was trying to put my finger on, and just a really clean and fun looking site. So lawyers need to have a little bit more of a both up-to-date and entertaining online presence, in my own opinion. So I like this one. If you're a lawyer, emulate it if you can. Folks, this has been a really, really fun show. I've enjoyed it. We've gone deep on a number of subjects, and really the time has gone by really fast. But it is our time to say goodbye to you all. Sadly, though, I must. Marty, we have to make sure and get you back on the show sooner as one of our semi-regular returning guests. We have to make sure that your next return is not quite so long in the coming. Thank you so much for joining us today.
Denise, pleasure as always, and thank you to Matt and Sarah. Very good.
All right. Is there anything you want to highlight before we go, Marty? Anywhere you're going to be speaking or anything going on with your firm or your blog that you want to let us know about?
Well, I'll be performing at the Aladdin Lounge in Las Vegas on the 3rd with my backup band. But also just follow me at Trademark Blog on Twitter. Thank you.
Wonderful. Thank you, Marty. Matt, great to meet you. Thanks so much for joining us today.
Likewise. Thank you, Denise. Thank you, everyone.
All right. How about with you? Anything going on at Loyola that you want to share with us before we get out of here today?
So the Antitrust Institute, which I'm a part of, has launched a new online program in global competition law that my friend Spencer Waller would kill me if I didn't put in a promo for. So, yeah, that's probably the big thing.
All right. Thanks so much. Sarah, great to chat with you again.
Yeah, thanks so much. It was fun. It always goes by so fast, like you said.
I know. I can't believe that we do this show for as long as we do. And it always feels like we could go on and on and on afterwards, but we'll spare you that. We will let you know that if you enjoy listening to the show and would like to hear even more of our shows, that you can tune in every Friday at 11 o'clock Pacific time, 1800 UTC. That's when we record the show live. We love it when you join us live. It's very fun for us, but we do recognize that not everyone can make that time slot. I'm amazed that we're able to get our panels together every week to all get together and chat for as long as we do. So definitely design your listening around your own schedule. Go to twit.tv/TWiL. Our whole archive of shows is there. And for listening in any number of ways, look at the subscribe aspect there on the page, and you'll get all kinds of suggestions on how you can watch or listen to the show. What else? You should get in touch with us between the shows. Let us know what you enjoyed hearing about, what you'd like to hear more about, what we haven't thought of yet that you'd like us to explore. You can email me. I'm Denise at twit.tv. Sarah is Sarah P at twit.tv, and you can find us on Twitter. The show also has a Facebook page and a Google Plus page if Twitter just doesn't give you enough space to express what you need to get across. But, perfectly fine to just paste a link into that Twitter box and send it our way. A great way to put something in front of us that you think we should be paying attention to. Thank you so much for joining us on this episode of This Week in Law. We'll see you next week.